Hello, everyone. I'm Sarah, and welcome back to my channel, Legal Logic, where we break down complex laws in simple, easy-to-understand ways so you can know your rights and protect yourself. Let me start with a situation that gets people in real legal trouble. You post something online. You believe it's your opinion. Then you get fired, suspended, or even questioned by police. And you say, wait, I have freedom of speech. The Constitution protects me. Here's the hard legal truth. The First Amendment does not protect everything you say, everywhere you say it, or from every consequence. And misunderstanding that single point is one of the most common and costly legal mistakes Americans make. The First Amendment to the U.S. Constitution is one of the most powerful freedoms in the world, but it's also one of the most misunderstood. The actual text begins with these words: Congress shall make no law abridging the freedom of speech. Notice something important. It says Congress, not your employer, not a private company, not a social media platform. The First Amendment protects you from the government, not from private consequences. This interpretation is not opinion, it is settled constitutional law based on decades of U.S. Supreme Court rulings. According to the U.S. Supreme Court and constitutional doctrine, the First Amendment protects political speech, religious expression, peaceful protest, criticism of the government. In Texas versus Johnson, 1989, the Supreme Court ruled that even offensive political expression, like flag burning, can be protected speech. Why? Because the logic of the First Amendment is this: a democracy cannot function if citizens fear punishment simply for criticizing those in power. That's the core reason this law exists. Here's where reality hits. The First Amendment only restricts government action. According to the U.S. Supreme Court, private employers, private schools, and private companies are not bound by the First Amendment. That means your boss can discipline you or fire you for speech. A social media platform can remove your content. A private business can refuse service. No constitutional violation occurs. This principle is confirmed repeatedly in federal case law and summarized by official guidance from the U.S. court system. Even when the government is involved, some speech is not protected. According to Supreme Court precedent, unprotected categories include true threats, incitement to imminent lawless action, Brandenburg of Ohio, 1969, obscenity, certain forms of harassment. Freedom of speech is not absolute. It is balanced against public safety and order. The law draws that line intentionally. Now, listen carefully. While the First Amendment is federal constitutional law, laws vary by state when it comes to harassment definitions, workplace speech rules, school and campus regulations. Specific rules in California may differ from Texas or Florida, especially under state civil rights laws and labor codes. Always check state-specific law. Most legal disasters don't happen because people are evil. They happen because people assume they're protected when they're not. The First Amendment is a shield, but only when used correctly. We're diving deeper into how the First Amendment actually works in real life and where most Americans trip up. Imagine this. You post a heated political opinion on Facebook or X, formerly Twitter. You assume it's protected because the First Amendment is supposed to guarantee free speech. Here's the legal logic. Private platforms are private rules. According to the Communications Decency Act, Section 230, social media companies can moderate content as they see fit. Consequence: you can be banned, muted, or suspended. No law protects you from private enforcement. But let's say a government employee posts something while on the job. That's different. Public employees have some First Amendment protection for speech on matters of public concern. See Pickering versus Board of Education, 1968. Yet this is balanced against the government's interest in maintaining workplace efficiency. The law balances individual expression against the functioning of government services. You post online, "I'm going to harm my neighbor." Even if you argue it's a joke, legally, this can be considered a true threat. Under 18 U.S. Code Section 875C, transmitting threats across state lines is a federal crime. State law example, California Penal Code Section 422 criminalizes criminal threats. Outcome, you can face arrest, prosecution, and fines. Freedom of speech does not protect speech that endangers others because public safety overrides individual expression. You make controversial comments at work, criticizing management or political policies. If you work for a private company, the First Amendment does not protect you. You can be disciplined or fired. If you work for a public employer, courts use the Pickering balancing test to decide whether your speech is protected. Example, Garcetti versus Ceballos, 2006, clarified that speech made as part of official duties may have no First Amendment protection. The law recognizes that government employees have rights, but employers also have a duty to maintain effective operations. Many Americans think posting anything online is safe. It's not. Even on private platforms, some posts can be criminal, e.g., threats, harassment, or incitement. Federal law, 18 U.S. Code Section 2339A/B, criminalizes providing material support to terrorist organizations. Certain posts can fall under this. State variation, California has stricter laws on cyber harassment and revenge porn than many other states. Platforms enforce rules to avoid civil liability, but state and federal laws still apply independently. Legal consequences can be severe. The First Amendment also draws lines around obscenity. Miller versus California, 1973, defined legally obscene material. It is not protected speech. Incitement to imminent lawless action. Brandenburg of Ohio, 1969, speech is protected until it directly incites violence. Hate speech, generally protected at the federal level unless it crosses into true threats or harassment. The law aims to maximize expression while minimizing harm. This balancing is at the heart of the First Amendment. Context matters. Where, when, and how you speak affects your protection. Audience matters. Private versus government entities, very different rules. Content matters. Threats, harassment, obscenity, or incitement are not protected. State law matters. California, New York, and Texas often add extra protections or restrictions. For example, California labor law provides additional workplace protections for political speech, while Texas law may differ. Always verify state law before assuming your federal First Amendment rights cover a situation. Before speaking, ask yourself, who am I speaking to? Government or private entity? What am I saying? Political opinion, threat, harassment, or obscenity? Where am I saying it? Public, private workplace, or online platform? What are the consequences? Could I face civil or criminal action? This step-by-step logical approach minimizes risk while respecting your rights. The First Amendment is a powerful tool, but only when used wisely. Misunderstanding it is a common trap, especially in today's digital age. Remember, freedom of speech does not mean freedom from consequences. Context, content, and audience determine protection. State laws add extra layers of complexity. By following this logical framework, you can speak confidently while staying on the right side of the law. If you found this guide helpful, subscribe to Legal Logic. We break down complex laws into plain English so you can protect your rights and make smart legal decisions. Hit the notification bell to stay updated because knowing the law before you speak can save you from serious trouble. This is Sarah with Legal Logic. See you in the next video.